5 seconds to go. Start. The above extract from the judgment of the High Court would make it abundantly clear that the single judge was duly apprised of the statements which were recorded by the investigating officer during the course of the investigation on 20th May 2016, 21st May 2016 and 9th June 2016, when the High Court took up the petitions under section 482. The investigating officer, upon the completion of the investigation, sought permission to submit the final report under section 173 before the competent court. This was noted by the High Court in paragraph 9 of its impugned order, which reads as follows. In the above extract, the High Court noted that a draft charge sheet was produced before it. The High Court nonetheless proceeded to formulate the issue before it as being whether the contents of the FIR revealed that offences of extortion and cheating had been committed by the respondents. But in its final order, the High Court quashed FIR of 2016 as well as other consequential proceedings arising out of the same FIR in relation to the accused under section 482. However, the High Court concluded that an alleged offence of extortion punishable under section 385 of the IPC had been made out on the face of the FIR against accused Karan Bhai and Magan Bhai, the fourth and fifth respondents, and the investigation was permitted to proceed against them for the offence of extortion. No offence as alleged in the FIR and draft charge sheet was held to have been established against the other accused. It is trite law that the High Court must exercise its inherent powers under section 482 sparingly and with circumspection. In the decision in Jugesh Sehgal versus Shamsher Singh Gogi, this court has held that the inherent powers do not confer an arbitrary jurisdiction on the High Court to act according to whim or caprice. In Simrikhia versus Dolly Mukherjee, this court, in another context, while holding that the High Court cannot exercise its inherent powers to review its earlier decision in view of section 362 of the CRPC, observed that the inherent powers of the High Court cannot be invoked to sidestep statutory provisions. This court held the police have a statutory right to investigate a cognizable offence under sections 154 and 156 of the CRPC. Subsection 2(1) of section 173 of the CRPC provides that after the completion of investigation, the police officer in charge of the police station shall forward the final report to the magistrate, who is empowered to take cognizance of the offence alleged in the report. Before taking cognizance of the offence, the magistrate has to apply their own mind and is not bound by the conclusions drawn by the police. In Pratibha versus Rameshwari Devi, a two-judge bench of this court has held that the High Court can neither direct an investigating agency to submit the investigation report before it, nor can it quash a criminal proceeding under Section 482 relying on such a report when the report has not been submitted to the magistrate. Stop.